Hello guys, today we're going to look at Chapter 5, the court system, and hopefully everything you sort of need to know about the courts. Probably not everything, but at least the majority. Let me reorder the screen here just a little bit. There we go. So the court system. So trial courts are our first type of court system that we're going to look at. Trial court systems are pretty much the basic court systems that we think of, both in civil and in criminal cases. Trial courts are there to listen to testimony. So they're going to listen to witnesses from the police, from the defendant's side, the prosecution side. They're there to consider evidence, be it physical pictures or actual items. And they're going to be the ones that decide the facts in disputed situations. And so that's what a trial court is there to do, okay? We have other types of courts that do not listen to that type of evidence unless there's specific situations involved. In both civil and criminal cases, there are always two sides. And we've touched on this briefly before. We always have plaintiffs, okay, in civil cases. And plaintiffs are just for civil cases. And that's the person who feels that they've been wronged by another person or by an organization or by a group. They're the ones who are bringing the case. Typically, we call that, it's the person suing somebody. So the plaintiffs are the ones doing the suing or accusing someone of having hurt them through some type of negligence or forgetting or not following a contract correctly. Prosecutors are in criminal cases, okay? And a criminal case is the government charging someone with breaking the law. So if you're caught speeding through a school zone and you go to traffic court, the prosecutor is the police officer accusing you of speeding. And if you want to fight that ticket, you can then fight that ticket. If you fight the ticket, you will be called the defendant. And both civil and criminal have defendants. Okay, it's the same thing. And it's simply the person accused of committing the wrong. Whether it be breaking the law or hurting somebody, or breaking the contract. And so those are defendants. And both civil and criminal have those two sides. Remember, plaintiffs are civil, prosecutors are criminal, defendants are both. In the United States, we have what's called the adversarial process. And the idea behind the adversarial process is that you are essentially starting on a level playing field. You have two sides and a independent, neutral judge and jury. And both sides are going to compete with each other, are going to present their best cases, their best evidence, their best testimony to convince the judge/jury that they are right. Okay? If you watch the TV show Law and Order, you know the prosecutor is the one trying to convince the jury that this person did that. The defense is trying to say, no, we didn't do that, or it's possible that someone else did it or is responsible. And so really, when it comes to the adversarial process, judges and juries are very key to the way the systems work. Because they're the ones who will end up making important decisions and eventually can determine guilt or innocence. So let's look at the roles here of these two. So judges. A judge's job is to be neutral. Okay? They're not there to choose either side. They are there to preside over the trial. They're there to make sure that both sides follow the rules. They are going to interpret the law. So if you have a question about a piece of evidence being admitted, if there's a concern about that, the judge would make a decision over what's admissible, what's not admissible. Were your rights violated? Were they not violated? They are there to protect those rights, okay? Both the rights of the defendant, and of the prosecution. In non-jury trials, you have the option to have a non-jury trial in the United States. In a non-jury trial, the judge is the one who's going to determine the facts, observe, weigh the facts, and render a judgment. You are guaranteed a jury trial in the Sixth Amendment. Now, you can waive that right, okay? The Sixth Amendment is there for a criminal trial. You're guaranteed a trial by a jury of your peers. You also have the same right in the Seventh Amendment, which is the civil cases. Now, you should note that in civil cases, it either has to be a certain type of lawsuit or over a certain amount of money that you're guaranteed a jury trial. The same goes, or a very similar situation there works for criminal. If you're doing a speeding ticket, they're not going to impanel a 12-person jury to determine if you are guilty of speeding in a school zone. Okay, a judge is going to do that. And simply put, jurors are people who serve on juries. And once you register to vote, it is your duty as a United States citizen to serve on a jury. And you will be called for jury. Now, if you're at college or you're out of the country, you can have that jury duty excused or waived, and they just put you further down on the waiting list. But when you get called for jury duty, you have to report to the courthouse to see if they need you. And they go through a jury selection process and all that stuff, okay? And here we see the steps in a jury trial. Even before this, there's a whole list of things that happen, from the crime being committed to the police investigating crime, arresting the person accused of the crime. Then there's the whole, you go in front of a magistrate judge to set what we call arraignment, guilty or not guilty, setting bail, presenting any initial motions there at the beginning of the trial. Then we have the grand jury part, and then we impanel a jury, what we call choosing a jury, impaneling a jury. All that occurs before we get actually to a trial, okay? But here are the steps. There are 14 steps here in a jury trial. The first one is the judge comes in, all rise, hear you, yada, 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 all that good jazz. They actually say all that. And we have the opening statement by the plaintiff or prosecutor. They lay out their case. Here's what I am going to prove. Here's what I'm going to show happened. Remember, if it's a plaintiff, it's by the preponderance of evidence. So I'm going to show you enough evidence to make you believe that this is what happened. The prosecutor has to do it. I'm going to prove this happened beyond a reasonable doubt. Not beyond any doubt, but beyond a reasonable doubt. Then the defense gets to stand up and goes, yes, the prosecution is going to try to prove this, but we're going to show that this is how it happened, okay? Not the way he said, but the way we believe it happens. And then we get to the presentation of evidence and witnesses by the plaintiff or by the prosecution. So this is where they lay out their case in a very orderly, step-by-step, precise, precision manner. They're going to set it out. Here's this witness. Here's this piece of evidence. Here's this. And they get to examine that evidence. So they put a witness on the stand, and they're going to go through questions. Did you see this? What happened here? What is this? Did you see that person do that? Then that evidence or witness gets to be cross-examined. The defense has the chance to say, well, how about this? They get to question them in return. Once there's a cross-examination, there's what we call a redirect. Okay, so after the cross-examination period, if the defense has raised a particular question or called something into question, the prosecution can then challenge that one last time. Once the plaintiff and prosecution get all that stuff done, their evidence and witnesses have been examined, cross-examined, and if necessary, redirect examination. Then there's a period very briefly where they rest their case, and any motions that are filed by the defense are then examined at that moment. Then the defense gets to present their case. And it's the same process, but just sort of in reverse order. The defense presents an evidence or a witness. They get to question it. Then the prosecutor or plaintiff gets to cross-examine that person or that evidence and challenge it. And then, if necessary, if needed, there is a redirect period. Okay? Once they rest their case, once they close their side of the argument, then the plaintiff or prosecutor opens up with a closing statement. And it's a summation. It's the closing paragraph of a paper. Think of it like that. Okay? It's their closing argument. You summarize everything. Here's what we've shown you. Here's what we've given you as evidence. Here's who you've listened to. And it all proves this. It proves that this person did this. Okay? Then you have a closing statement by the defense. The last chance of the defense to say, that's what the prosecution or plaintiff has showed you, but here are the holes. Okay? Remember this. Look at that. They couldn't have done it because of this. It's not my responsibility because of that. Okay. Then if necessary, there's a chance for a quick rebuttal argument by the prosecutor, sort of getting the last word in. Once both sides are done, the judge is going to look at the jury and give the jury instructions. And they're going to tell the jury, here are the charges that you can look at. if we're looking at manslaughter charges, here are the rules of evidence and the standards that must be met. If we're looking at murder one, here are the rules that you must meet before you can say this person's guilty. And once he's delivered those instructions to the jury goes into a separate room and they begin deliberating. They talk amongst each other. They look over the witness that was the evidence and witnesses' testimony that was presented. They can examine any of the evidence again. They can listen to the testimony again. They can actually deliver questions to the judge for clarification if needed. Once they're done with that, they will develop a verdict, guilty or not guilty. They can also have a hung jury. We're split. We cannot have a complete agreement. Now, in criminal cases, a jury has to 100% agree with the decision. If you are arrested for murder, a jury cannot convict you of murder unless all 12 people agree that you're guilty. If one person says he's not guilty, you have a hung jury. You cannot make a decision. Vice versa, 11 people cannot say you're not guilty and one person say you're guilty and you be declared not guilty. You have a hung jury again. Okay? If you have a hung jury, if you declare yourself to be hanged, a lot of times the judge will issue a mistrial and the prosecution can, if they want to, file charges again and have a whole new trial. If you are found guilty, then they move into a sentencing phase of the case where the judge looks at what goes on. Sometimes a jury can recommend sentences, and a judge will then sort of apply the law and the consequences for the decisions or actions that you committed and go from there. If you're found not guilty, you get to go home. Okay? It's a good thing. In a civil case, juries, in a civil case, the jury verdict doesn't have to be all or nothing. Okay? It doesn't have to be everyone agrees to get you. If 7 people on the jury find that you did it, you did it. Okay? You're convicted. You have that conviction coming back from that jury, and they're going to be awarded. That person's going to be awarded money from you. You're going to have to pay them. If you don't have a jury trial, the judge gets to make that decision. In a civil case, a lot of times the jury will make decisions about how much money to return or to give to the person who feels slighted or who feels injured. So it's a really complex and dynamic system in there. Once you get through the jury trial, if you are found guilty and you just know you didn't, you're going to appeal your case, you go to the appeals court, okay? You're going to ask the appellate court to review the decision of the lower court, okay? Generally the trial court. And now here's the thing with appeals court. You can't say, I think they misread the evidence, okay? Appellate courts don't hear evidence, okay? They don't listen to witnesses. They don't have juries. It's generally a group of judges. It can be 3 or more judges. Generally, it's always an odd number. And the judges are going to listen to your appeal and decide if your trial was fair and right, okay? Fair and right. If there was a serious breach in your privacy, let's say the police obtained evidence illegally, they didn't have a search warrant, they didn't have probable cause to access that evidence, then a judge could throw out that evidence and give you a new trial because you didn't have a fair trial. They don't decide if you're guilty or innocent, okay? They decide, did you have a fair trial or did you not have a fair trial? Was there an error of law made? Okay? They want to make sure that the judge and the lawyers did not do something wrong that would have clouded your ability to have a fair and impartial trial. When an appeals court issues a decision, it's what's called an opinion. Okay? And generally these opinions will set rules for other courts to follow. Okay? And there are 3 types of opinion. A majority opinion. If you have a panel of 7 judges, 4 judges say, this is what we believe, that's the majority opinion. And one of those judges will write why they believe that. The other judges, let's say 2 judges of that 7 were disagreed with the outcome, they write what's called a dissenting opinion. Okay? They're wrong because of this. That 7th judge, let's say he voted with the majority, he said they were right, but they were right for different reasons than what they said. Okay, so he believes that there's another point of law that proves that the appeal was correct. Okay, and so he would write she would write what's called a concurring opinion. And then, of course, at least at the federal level, you have at the top of that the U.S. Supreme Court. Now, there are two different court systems in the U.S., state court systems and federal court systems. State courts are going to hear in cases that involve state laws and oftentimes are more specific to deal with specific types of law. You're going to have family courts. You're going to have divorce courts, traffic courts. You're going to have, in North Carolina, we have the North Carolina Superior and North Carolina District Courts. And they break out differently. Counties will have various subsets within magistrates of that, okay? Federal courts hear federal laws, okay? Things that deal with disputes between states. If you attack a post office employee, okay, that's a federal crime. If you commit a crime on a federal military base, on a National Guard base, that's a federal crime, okay? And you're going to go to a federal court for that. So there are three levels. You see U.S. District Courts, U.S. Courts of Appeals. There's a subset that's sort of outside of that. It's called U.S. Tribal Courts, and they're on the Native American reservations. And then we have, of course, the Supreme Arbiter of all cases, the U.S. Supreme Court, okay? In the U.S., we also see some influence of what we call international courts, okay? Now, we're not directly subject as a whole to international courts. But courts have been set up under the United Nations. And I have here for you three instances of courts, three examples of courts that the U.S., if necessary, must obey law, obey rulings from. The first one is the International Court of Justice, located at The Hague in the Netherlands. So if we commit some crime, violate trade agreements or something in the world under the UN's guise, the International Court of Justice will take care of that. The International Criminal Court, we're looking at war criminals, okay? We sort of set up the first International Criminal Court at Nuremberg, okay, when we tried Nazi war criminals. The Court of Arbitration in Sports is one that's been recently in the news with the 2016 Olympics when WADA basically said that the Russian government and Russian athletes have been in a conspiracy to dope and then cover up the doping. The Field and Track Sporting Federation banned banned all but one of the Russian athletes. They appealed to the Court of Arbitration in Sports, the CAS, and the court said no. The federation, the federal body of that sport, was right in suspending those athletes. The same thing happened when the Paralympic Games suspended all of the Russian Paralympic athletes. The Paralympic athletes appealed in the Court of Arbitration in Sports, and the CAS said no, you are all in fact suspended and banned from the 2016 Rio Paralympic Games. And that's sort of the breakdown of courts. We're going to get more in depth later on. I hope you have a great day, and I'll see you later.